Is this real? Or is this just a ride? The world is like a ride. You think it's real? It's just a ride. We can change it anytime we want. It's only a choice between fear and love. The world is like a ride. You think it's real? It's just a ride. We can change it anytime we want. It's only a choice between fear and love. The ride goes up and down, round and round. It has thrills and chills, and it's very brightly colored. It's up and down, round and round, and it's very loud. Don't worry, don't be afraid, it's just a ride. And we can change it anytime we want. It's only a choice between fear and love. Why are we here?
I think we're part of a greater wisdom than we will ever understand. A higher order. Call it what you want. Know what I call it? The big electron. Whoa, whoa. Whoa, whoa. The big electron. Whoa, whoa. Whoa, whoa. It doesn't punish, doesn't reward. It doesn't judge at all. It just is, and so are we. For a little while.
Well, greetings, programs. It's November 19th, 2017. You're in Red Pill Sunday School here on UCY.TV. Thank you so much for joining us this week. I apologize for my absence last week. I was quite sick, quite ill. In fact, you probably noticed that my voice is going really low at this point, which is because I'm recovering still from a little touch of the, I don't know, chest cold, flu, whatever it is. And so I'm attempting here to pre-record a show for you that has to do with a little documentary of mine. Now, I said last time that we were going to go over a little bit about the Bundy Ranch. Not so much about the Bundy Ranch incident, but all that was behind that false patriotism, that false notion that the Bundys had some right to allow their cattle to graze on federal lands, etc., etc. All of the patriot mythology, all of the stuff that drives the quote-unquote truth movement in its package of lies. The lies that we love to tell ourselves. Of course, Samuel Johnson, I believe it was, in his dictionary, said that patriotism is the last refuge of a scoundrel. And what has happened, of course, is that our patriotism has been turned away from the self. Turned away from self-governance, the idea of being self-governing, of living in a state, a people, a tribe, or even just a family of self-governing people, teaching your own children your own values, your own moral law, according to, of course, that which is the foundation of our system of law, which is the Bible. This has been taken away, and our patriotism has been redirected towards exactly what it should not be, which is a standing army connected to a central government that has literally taken over through a little event called the Civil War. Now, we had two different kinds of Congresses. We have a legitimate Congress and we have a illegitimate or de jure and de facto system of government in place. Now, this is not such a strange thing to consider because all governments have a de jure or by law of law and a de facto, or illegitimate, or not by law. So, you have the legitimate and the illegitimate. This is always the case, right? Congress creates the illegitimate government that is the centralized, quote-unquote, state that is not within the United States of America. Again, we're talking about Washington, D.C., the District of Columbia. Now, why is it that we had a de jure government? Well, because the de jure government, which is Congress when it is assembled for such, as such, where it's representing the states, the quote-unquote people, this is the de jure government. However, it created, as we talked about before, and if you haven't listened to our previous couple shows, you might want to, so that you understand all this, it created what I like to call an offshore corporation, even though it's not offshore. In fact, there's no shore or land at all involved. It's purely a maritime admiralty law operation, which is why we fly the American, i.e. United States flag, why it has its gold fringe, which means that it's an admiralty situation, the law of the flag. Maybe we'll read those definitions later. But this is all in my book as well, either one or two. What I want to start off talking to you about again is how it is that your patriotism has been flipped, has been misguided, has been turned into basically the worship of a modern, feudal system under a different name. Now, to give you an example of how foolish it is to be patriotic of a central government, let's consider citizenship to, say, England or Scotland or any of these countries, right, that are all under one central monarchy, a sovereign that has no, essentially, law above it. Of course, to be a sovereign, you have to rule over others. No point in being a king if you don't have subjects, right? So what's the point of sovereignty unless you're ruling over other people? It's a catch-22. You can't be a sovereign unless you rule over people. You call yourself a sovereign without any subjects, it's a mute point. There's no reason to call yourself that. And this is, of course, again, why we are told that God, i.e. Jehovah, the author of the natural law, if you will, remember to think metaphorically, the author and creator of nature and its law, should be, of course, our only sovereign, our only controller. Okay, again, it's a beautiful concept. You just let yourself go and accept it and understand it, and stop being afraid, like I have been for so long in my life, to be able to say these words. Now, you're going to look on the internet, and you're going to see that all kinds of videos out there, all kinds of sites and Gnostic stuff that's going to tell you, oh, but, the word, the devil means God. The devil's name is God. Baal means God. All these different words mean God, and I understand that, and I've tried to explain this so many times, that the word God is a generic term. It means absolutely nothing until it's qualified. Any one of you can be a God, because God means a judge. God means mayor. God means a governor. Governor means a president, a king. It means any person in power. And I say person, not man. Person. Only persons are gods. Corporations. You're going to see, if you look up the word B-A-A-L as a generic term, it actually means God. Does that mean that the capitalized B-A-A-L and the variations of its name is God? Well, if that's what the God that you follow, then certainly. If you don't follow the God of nature, you want to follow some other God, including men, who act as kings and popes and magistrates and presidents, well then by all means, that is your God. Quit taking it literally. Quit taking the word God to have only one meaning or one comprehension or understanding. It's a generic term. And once you understand that, whole worlds open up to you. You stop reserving this one singular concept that it can only be one thing, that it can be multiple things, and that unless you actually look and see what it is you're talking about. What God is on our money, do you think? Seriously, what do you really think that Jehovah is the God that is spoken about when it says, "In God we trust"? Do you really think that that is the God? The God that you're supposed to be, you're supposed to make a choice between God and mammon. Do you really think that that is the God that is on your money? In God we trust. Really? But I don't want to get sidetracked with this. I just want you to understand that words have so many different meanings. And of course, those who are the creator gods, the magistrate, the founding fathers, the president, who Congress, whoever is the sovereign is, of course, and whoever is the judicial is going to define the terms. That's what they call the terms of art. They call it terms of art because you're living in a matrix, in an art form. You're living in a fiction, and I can't stress this enough. Today I want to talk about that. I want to explain to you what this little matrix that we have going on in the United States is. And we're going to do that by going to the true history of the United States. What is the true history of the United States? There's no such thing, except what they've left us in their own words, in their laws. There is nothing else. There is nothing else you should be looking at. You should not be looking at their lifestyles, at what they wrote outside of the government. No, you should be looking at the laws, the primary source for what they left us. What they truly gave us as their inheritance was a shit kick in the ass with all these laws. That is what you should be focusing on, not the romanticism, not the patriotism. Okay? Those who promise security and protection. What does the Bible say? That is exactly what those who will destroy us are those who offer us security and protection. That's what the Pope is offering. That's what the United States, the United Nations is offering us. That is how we will be destroyed. Ben Franklin warned about it when he said, I believe, maybe it was Thomas Jefferson, I can't remember, when he said that those who prefer security over liberty deserve neither, etc., etc. You're warned about it all throughout. And see, this is because you've been taken away from the notion of self-government and you've been put under the strict Roman law. How did that happen? How did the law of the sea become the law of the land? What does law of the land mean? It means simply the due process of law that comes from the court. It is not a romantic thing at all. It's not something you should be worshiping. The law of the land is not a good thing. The law of God is not the law of the land. When a church tells you to follow the law of the land, it is not telling you to follow the Bible, the scriptural law, the moral law. It's telling you to follow the legal law. Legal is that which is opposed to God. That's which is opposed to nature. That which is art, artificial. Okay? Due process of law. Well, that's the court system, my friends. Nothing is more corrupt than our court system. Let us examine, then, the history of the even when the courts were an honorable institution, if that is ever really a possibility. Let us go back and see what they wrote in their decisions, what they wrote in their opinions. Because what you're going to see is that they were very concerned, even at the inception of this United States of America, that this was a trick. There's something wrong here. Remember what Patrick Henry said, is what the hell? How do these guys get off calling themselves the people instead of the states? We the states are forming a more perfect union, not we the people. We talked about this, so I won't go into that. But if you haven't seen listen to the last couple shows, we talk about that in those. So let's focus on a little thing called Admiralty Maritime Law. Let's focus on what I call the Great Flood of America. Oh, well, that's sacrilege to the Bible. The Great Flood was a biblical. No, folks. Remember, water. What happens when you're underwater in the banking industry? It means you're in debt. What happened? What was the Great Flood? What is the true Great Flood? It's the flood of the law of the sea over the spiritual law, the law of nature. It is the flooding of the land with water, virtual water. Come on, let's be realistic here. We're talking about fiction. So I want you to put on your fictional thinking caps, your metaphoric thinking caps, and understand what I'm trying to say here. And understand also that that is what the courts are going to be talking about. How water is flooding the land. Evil is covering the light. Now, over the years, there have been a lot of groups that have gotten together for the purpose of mutual benefit research, if you will. One of those groups created a document called The Secret of the Special Maritime Jurisdiction of the United States Exposed, revealing the most repugnant fraud ever perpetrated on the people of the United States of America. A brief dissertation exposing the true nature and cause of modern criminal accusations. And this was a group called Valiant Liberty. They did this in 2001. And it starts off by saying, of course, repeating what Luke 11:46 says, "Woe unto you also, you lawyers. You have laid men with burdens grievous to be borne, and you yourselves touch not the burdens with one of your fingers." Now, it's interesting because laid, of course, is laden. Birth certificate is a bill of lading, like a ship gets a bill of lading or bill of your cargo. And of course, born, grievous to be born, has an E on it, and that means to carry. So born means to be born, but born with an E means to carry. So, you lawyers, you've laid men with burdens grievous to be borne. You've put cargo on men to carry that you yourselves will not touch the burdens of with your fingers. Luke 11:52 says, "Woe unto you, lawyers, for you have taken away the key of knowledge. You entered not in yourselves, and them that were entering in you hindered." And that's true, right? My people perish from a lack of knowledge. Boy, nothing could be more true than that fact today. And what we're talking about today is the modern feudal system that was created by this incorporation of the municipal corporation called Washington, D.C., which they refer to as the corporation, as we talked about, and then, of course, ceding the power of the seat of government of the United States of America in that corporation that they created inside Washington, D.C., a foreign entity, a foreign thing, offshore corporation is what I like to call it, municipal corporation, that is not part of any of the states united whatsoever. It is completely foreign to all things of the United States of America. All things. Even the Congress of the United States of America, when assembled in its legitimate, or what used to be its legitimate form, Washington, D.C. is separate from that. It is not part of that. It is a foreign corporation, municipal corporation, which houses the seat of government, as we spoke of and read from congressional record. That is where the United States, or i.e. the corporation called, quote, United States, not the, but United States, lies. That's the seat of government, but its jurisdiction, its area, federal area, according to the Buck Act, extends to all of the things we're going to be talking about today. Which is why you have this thing and this battle between states' rights and federal lands, state land and federal land, private land and public land. This is why you have this battle. Now these guys, they put together some quotes. I won't read the full thing here. You can find this by yourself. I just gave you the title, Secret of the Special Maritime Jurisdiction of the United States Exposed. And basically, let me just read you a few quotes so we can understand that this was a concern from the very, very beginning. They knew that this was the real goal of these Freemasons that started this country. They called them the Founding Fathers. The Bible says, call no man your father. This is the natural law. No man is your father. No man is your sovereign. Never act per the Son or in person to any father but Jehovah. It's real simple. It's just the law. I'm not being religious. Here is our problem, okay? The Supreme Court has held in United States versus Hudson and Goodwin, 11 U.S. 7th Circuit 32, 1812. So we're back in 1812 here, folks. The Supreme Court has held that there is, quote, there is no common law offenses against United States, the United States. Only those acts which Congress has forbidden with penalties for disobedience of its command are crimes. Okay, there is no common law, which includes the Bible, in the United States. The common law, as we call it, which was transferred over from England, exists, if you will, only within the private lands of the states. That which was not given over to the holdings, the trust, and the ownership of the United States. You're going to be surprised at how much land is actually held by the United States. You think, for instance, that Nevada is a full state, when actually 83% of Nevada is federal land. It is not part of the state of Nevada. Okay, same with Utah, same with most of the western states, and that's what we're going to be talking about today. There is no common law in 83% of Nevada, is what I'm trying to tell you. There's no common law in about 53 or so percent of Utah, because it's federal land. It is a foreign corporate structure that is controlling that land. It is not part of the state. I can't tell you, I cannot stress how important this is. Okay, Supreme Court. There is no common law offenses against the United States. Bouvier's 1856 edition of the legal dictionary, when you come to a maritime cause. What is a cause? What is this notion that there is no common law crime or cause against the United States? Maritime cases are those arising from maritime contracts, whether made at sea or on land. At sea or on land. That is, such as relate to the commerce, business, or navigation of the sea. The sea is not a real thing, folks. The sea is a jurisdiction of water. When water covers a land, it is no longer considered as land. Okay, this is a virtual sea. As charter parties, enfreightments, maritime loans, hypothecations, contracts for maritime service, etc., contracts relating to maritime insurance, those between owners of ships. There are maritime causes also for torts and injuries committed at sea. Again, there is no tort in the United States or against the United States, because you're not under the common law. In general, the courts of admiralty have a concurrent jurisdiction with courts of law of all maritime causes, and in some cases, they have exclusive jurisdiction. Now, 1851, at least, we're going back to 1851, where the Supreme Court recognized that the Congress has the power to extend the jurisdictions of admiralty and maritime, the law of the sea, causes to the land, the law of the land. In other words, when we say to the land, we're saying to the due process of law of the courts, turning the courts from common law into admiralty law, law of the sea, of which you are a citizen or vessel of, you are on that. Remember, folks, Jesus walked on the water. Jesus, in other words, walked on the commercial water. He did not need a vessel. His vessel was his Father, God. We call the state, or Washington, D.C., our father. Our president is our father, our founding fathers. Therefore, we need a vessel to exist and float upon their commercial sea, which means we never touch what's under that virtual sea, that legal jurisdiction, which is the land. You see what I mean by the Great Flood. So back in 1851, the courts started. There was plenty of times where the courts recognized and were very disturbed by the fact that this was obviously going to happen, that the sea was going to be extended over the land. Because remember, you can't own land. As long as you're in a vessel of the United States, you cannot touch the land. You cannot own it. You cannot be, I should say you can own it, but you have no right of disposal. It is never your land. It is always the property of the vessel in which you are using, because you're always floating above it. You're never touching it. Remember, we're talking metaphorically here. You must think metaphorically. You must think figuratively, or you'll never understand how the law works. Here's what the holding of the High Court, the Supreme Court, it pretty much says it all here. This power of admiralty jurisdiction, this is again 1851, is as extensive upon land as upon water. Wait a minute, how can the law of the sea be, how can you put that over the land? That doesn't make sense. Well, it's figurative. The Constitution makes no distinction in that respect, and if the admiralty jurisdiction in matters of contract and tort, which the courts of the United States may lawfully exercise on the high seas, why are there watermarks, high watermarks in the mountains, folks? Why do you have watermarks in places where there's no water? It's the high seas. It's piracy. It's fake. It's not real. And if the Admiralty jurisdiction in matters of contract and tort, which the courts of the United States may lawfully exercise on the high seas, can be extended to the lakes under the power to regulate commerce, it can, with the same propriety, i.e. property, and upon the same construction, be extended to contracts and torts on land when the commerce is between different states. This is why they call it, and they insist on calling everything, interstate commerce. That puts it into the United States jurisdiction, which is admiralty, or i.e. law of the sea. This is why if you go private, you stick to intra, as in inside of the private lands of the state. You don't operate unless you open a trust and go through all the crap that these guys go through, and go through names like Obama went through so many names to go from the private to create your own person, put it in a trust, and then when things go bad like at Enron, they just ditch the name, they ditch the attachment, ditch the trust, nobody gets in trouble. Because they're not attached, they're not in surety to that person, it's their own. It's not property of the United States. Kind of difficult to explain. Just ask anybody in trust law and they'll explain it to you. The private man conducts intrastate, as it says on your dollar bill. It says this is good for private and public tender, legal tender. The vessel of the United States conducts interstate commerce at all times, because remember, your domicile is Washington, D.C., where the seat of government is. That jurisdiction of that goes through all public lands, or government-owned lands. Federal lands, I should say. Right? So here we are, wherever we do, because we're foreigners in the states that we reside, where we live, our persons are United States persons, not state citizens, and therefore we're always in foreign trade, foreign commerce. We're always under the jurisdiction of the United States because we're in foreign or interstate trading. Remember, all states are foreign to each other, and the United States is foreign to all other states and nations. So anything you do, any international trade or interstate trade, is going to be under United States jurisdiction. This is how they tricked us into this. I'm going to continue with the court case now. Quote, and it may embrace also the vehicles and persons engaged in carrying it on, that is, commerce between the different states. It would be in the power of Congress to confer admiralty jurisdiction upon its courts over the cars engaged in transporting passengers or merchandise from one state, which is capitalized, to another, and over the persons engaged in conducting them, and deny to the parties the trial by jury. Now, I don't know how many times I got to tell you this. You don't have constitutional rights when you're in the United States. Constitutional rights extend to those who are not in the United States, i.e. the private citizens, the private lands that are still under the control of those private people, the states. Okay, if you don't understand the difference between people and people, common people and private people, a class structure that is a capitalized P, which we call the state, well then, you'll understand by the end of this show, trust me. So, here again, we see that admiralty law can be put up to vehicles or persons, and over the cars in transporting passengers or merchandise from one state to the other. So, highways, my friends, are virtual waterways. And if you look that up, what's her name? Vicki Davis has done wonderful things on the notion of virtual waterways and how that works. If you want to understand that, yeah, go to Vicki Davis's site, Channeling Reality, I believe is what it was called. But she did a big thing on how everything has been turned into virtual water. The Great Flood. And over the persons engaged, connect them to deny the parties the right, but you don't have the right of trial by jury, okay? The fact that they still pretend that you do is it just goes to the notion that of supporting this beautiful, beautiful quote, which is, None are more hopelessly enslaved than those who falsely believe they are free. Can't remember who said that. But let me repeat that. None are more hopelessly enslaved than those who falsely believe they are free. This whole system is set up to make you believe that you are artificially free. That you are not in a matrix, a legal matrix. That you are not a United States citizen instead of a state. You believe that you are part of the people. That you believe all these bullshit notions. These patriotic, this crap that we've been taught and inducted with since birth. The conditioning is so powerful. I'm going to go on. It says, now, the judicial power in cases of admiralty and maritime jurisdiction has never been supposed to extend to contracts made on land and to be executed on land. But if the power of regulating commerce can be made the foundation of jurisdiction in its courts, and a new and extended admiralty jurisdiction beyond its heretofore known and admitted limits may be created on water under that authority, well, the same reason would justify the same exercise of power on land. That's from the Propeller Genesee Chief et al. Versus Fitzhugh et al. 12 Howe, and that's from 1851. Very next year, in 1852, the Supreme Court warned that this admiralty or maritime threat to liberty was encroaching on the land and morphing itself into an air-breathing creature, just as a harmless tadpole transforms itself into a frog, and thus is a really ugly frog we're talking about. If you had ever seen a tadpole gradually go through this miraculous process, you might never believe that such a transformation could occur, changing a harmless water-breathing creature into an air-breathing predator. But let's read from Jackson versus Magnolia. This is 1852. Next to revenue taxes itself, the late extensions of the jurisdiction of the Admiralty are our greatest grievance. This is the court speaking. The American courts of admiralty seem to be forming by degrees into a system that is to overturn our Constitution and to deprive us of our best inheritance, the laws of the land. It would be thought, in England, a dangerous innovation if the trial of any matter on land was given to the Admiralty. Folks, this quote is a warning against exactly what we're in today. Everything is in admiralty. Every court that you go to that is a United States court is an admiralty jurisdiction. Has the Congress expanded this admiralty and maritime jurisdiction? The answer is a definite and emphatic yes since then. One only need examine the codification at Title 18 of United States Code, Section 7, which is called Crimes and Criminal Procedure, Part 1, Crimes, Chapter 1, General Provisions. Section 7, Special Maritime and Territorial Jurisdiction of the United States, defined. The term Special Maritime and Territorial Jurisdiction of the United States, as used in this title, includes the high seas, any other waters within the Admiralty and Maritime Jurisdiction of the United States, and out of the jurisdiction of any particular state, and any vessel belonging in whole or in part to the United States or any citizen thereof, or to any corporation created by or under the laws of the United States or of any state, territory, district, or possession thereof, when such vessel is within the admiralty and maritime jurisdiction of the United States and out of the jurisdiction of any particular state. Now here you see they're defining two different realms, two different jurisdictions, one of the state, the private or foreign state, and one of the lands that the United States or whatever it is under contract that the United States has taken and ceded from those states. 2, any vessel registered, licensed, or enrolled under the laws of the United States, being on a voyage upon the waters of any of the Great Lakes, etc., any lands, any lands reserved. So, admiralty jurisdiction, because it's special or special, It includes any lands reserved or required for the use of the United States, and under the exclusive or concurrent jurisdiction thereof, or any place purchased or otherwise acquired by the United States by consent of the legislature of the state in which the same shall be for the erection of a fort, etc., or any needful building as the Constitution says. However, what you're going to find out today is that before most of the western states especially, but all states, you see, they had to redo their constitutions. For instance, Nevada, which we'll talk about, in order to even be allowed to become a state in the territory of the United States, they had to give up all right and claim to all unappropriated lands, public lands. That meant that 80-something%, more than that back then, was given to the United States. Nevada is 17% Nevada and 83% quote-unquote United States. You got to understand this, folks. And where do we live? What part do United States citizens inhabit? Do you think it's that 13% where all the private people live? No, that would be the state. That would be the actual state, the actual people. Nope. Sorry, you're in the federal areas. And if you're not, you're still bound by United States law because you're traveling under its maritime jurisdiction, in a foreign state. So no matter where you go, why is it that when you trespass on private lands you're in trouble? Because it's not your land, it's not the United States land, it's the land of the state. And you're in United States jurisdiction. Anyway, it goes on, any island or rock. But the most important thing here is any land reserved or required for the use of the United States is because it's a jurisdiction. It's not part of the United States. It is a jurisdictional hold to contract or constitutional requirements, etc. Any aircraft belonging, it just goes on and on and on. All of these are vessels. And remember, citizen ships are vessels. Any vehicle used or designed for flight or navigation, etc. It goes into space, it goes into the moon. Any place outside the jurisdiction of any nation with respect to an offense or by or against a national of the United States, etc. Commercial crimes is also defined. Most importantly to that, and this is why we mentioned this earlier in another show, but it says addiction to narcotic drugs and use of marijuana will be treated as if such were a commercial crime. Why is it still illegal in every state under federal law to smoke marijuana? It is a commercial crime. You are thought to be acting 100% of the time in commerce, in other words, in the vessel citizenship of the United States, where it is illegal. And remember, you're smoking it on federal lands, public lands, anywhere that's public. That's why your little state license doesn't protect you. States have no right to go against the United States law when it has to do with United States citizens or United States land. And we will cover this in triplicate. An Ebsworth lecture of 1994, Infra Proctor Wiswall states that Congress has been repeatedly held by the court to have the power to extend the admiralty and maritime jurisdiction by statute, and Congress has repeatedly exercised that power. This document goes on to say that what many of the victims accused of maritime crimes don't realize is that admiralty and maritime jurisdictions were merged with the law and equity jurisdictions in 1966. It says, see Federal Rules of Civil Procedure, notes to supplementary rules for certain admiralty and maritime claims. All four causes of action, or nature of the cause, which were once separate and distinct, are now rolled into one set of rules and indistinguishable from one another in our modern courts. Federal Rules of Civil Procedure, Rule 1 provides that, quote, These rules govern the procedure in the United States District Courts in all suits of a civil nature, whether cognizable as cases at law or in equity or in admiralty, with the exceptions stated in Rule 81. And Rule number 2 provides that, quote, there shall be one form of action to be known as civil action. Rule 9H provides that in part, if the claim is cognizable only in admiralty, it is an admiralty or maritime claim for those purposes, whether so identified or not. They don't have to tell you. And they're not going to tell you. These rules shall not be construed to create a right to a trial by jury if the issues in an admiralty or maritime claim within the meaning of rule. So in other words, this whole concept of a right to trial does not exist in the maritime jurisdiction of the United States. When you walk into a court, you see that American flag, you know where you are. When it's covered in the gold fringe, that was a presidential directive specifically meant to cause you to know that you're in a maritime, international type or interstate commercial court. That is the purpose of that. The courts have also held that the power of punishment is vested in the legislature, not in the judicial department. It is the legislature, not the court, which is to define a crime and ordain his punishment. Remember, the courts are just there to administer what is already existing. The legislature may declare that the doing of certain acts shall constitute the offense of sodomy and may ignore, if it sees fit, the common law elements of the offense. Under Texas law, no act or omission is a crime unless made so by statute. The courts have also stated, for instance, it is old hat, meaning custom, that a court called upon to do equity should always consider whether the petitioning party has acted with unclean hands. This is again a figurative term, meaning are you in honor, standing in honor. This consideration is rooted in the maxim that he who comes into equity must come with clean hands. Under the doctrine of unclean hands, a court may refuse to grant equitable relief to a plaintiff who has been guilty of unlawful or inequitable conduct regarding the issue in dispute. Now, you cannot have clean hands as a United States citizen. I'm sorry to tell you. Your hands are already dirty. You've already taken the mark. You've already admitted that you need help governing yourself. You're not self-governing. You're not following the Bible. So, yeah, you don't have clean hands. It is well settled that a party seeking equity cannot come into a court with unclean hands, etc., etc. So, this notion of having clean hands, United States citizenship is a fraud. And once you recognize the fraud, you can not call it fraud unless you cannot use fraud as an excuse or as a reason for not following the law until you quit, right? So you have no clean hands unless you actually quit that which is fraudulent. United States citizenship is certainly fraudulent. It is that which is opposed to the notion of the republics, which we call the states. In the section called How They Do It, he says, the process of bringing the harmless tadpole out of the sea and transforming it into a fire-breathing murderous predator on the land began, as near as the authors can determine, around 1851, again right before the Civil War, and recognized by the holdings of the Supreme Court in the case of Propeller Genesee Chief et al. Versus Fitzhugh et al. Supra, warning of the power of Congress to expand the admiralty jurisdiction of the federal courts. If the reader is still not convinced that the courts are exercising and enforcing a maritime jurisdiction, the following portions of Proctor Wiswall's lecture should be of some help. He says, in the United States, the first development noted is the 1966 merger of the old General Admiralty rules into the Federal Rules of Civil Procedure. Though several commentators made predictions concerning the effects of unification upon the substantive law of admiralty, it was not until the late 1970s that the Admiralty Court began to exercise with any measurable regularity the power to administer equitable remedies in admiralty cases. The delay may seem strange, especially in light of the quite rapid effects of the 1938 merger of the equity rules into the first federal rules of civil procedure. But the late Depression era was one of great social activism on the part of the federal government. And this faded seamlessly into wartime legislation, which appropriated control of private property. The district courts under the new FRCP were quickly forced by the volume of litigation into the wholesale application of equitable remedies in actions at law. The 1938 merger of law and equity rules left no loose ends. The procedure is entirely uniform regardless of the nature of the remedy pleaded, though of course issuance of an injunction requires at least an ex parte hearing in chambers. The 1966 merger, however, leaves 6 special supplemental admiralty rules appended to the body of the FRCP, and in order to apply those supplemental rules, it is necessary that the complaint specifically invoke the jurisdiction of the admiralty side of the court, so as to ensure that the action does not proceed on the law side if the common law is competent to supply an in personam remedy in the particular case. The effect of this has been to perpetuate an artificial distinction between the law and admiralty sides of the court, whereas the distinction between the law and equity sides has long since disappeared. The equitable power of the American Admiralty Court had earlier been held to derive from the first Judiciary Act of 1789, so it happened right in the beginning. To read some of the more important parts, Congress has been repeatedly held by the court to have the power to extend the admiralty and maritime jurisdiction by statute, and Congress has repeatedly exercised that power. The most direct recent exercise was the Admiralty Jurisdiction Extension Act of 1948, T46 U.S. Code 740, which gave the Admiralty Court cognizance in rem as well as in personam, so for one person or to all persons, of torts caused by a vessel on navigable water, notwithstanding that such damage or injury be done or consumed on land. A more detailed explanation given by Story or Justice Joseph Story, I believe that is, in his greatest work, commonly known as Commentaries on the Constitution. His exposition of the whole thing, the constitutional grant of jurisdiction, draws additional distinctions between the words admiralty and maritime, and in my reading he plainly declares that the purpose of the later, which is maritime, is not only to free the jurisdiction of the Admiralty Court from the shackles forged by centuries of writs of prohibition issuing from the courts of common law, but also, one, remember there's no common law in the United States, so Admiralty is free to do exactly what it has done, but also to enable the fullest development of seaborne foreign commerce in accordance with principles of maritime international law, and to enable the Admiralty Court to exercise its jurisdiction in rem upon all, in other words, beyond those causes which are founded upon maritime liens, notably in causes which affect the commerce and navigation of foreign nations. It is this second point made by Justice Story which most holds my interest, in stating that the word maritime has special significance in relation to foreign ships and foreign employment, so that when such are involved, the general maritime law enables the courts of admiralty to administer a wholesale and prompt justice. In other words, it's completely separate. As the courts of admiralty entertain suits in rem as well as in personam, they are often the only courts in which an effectual redress can be afforded, especially when it is desirable to enforce a specific maritime lien or claim in the nature of a pledge. Remember, you pledge allegiance to the United States. That is, for all intents and purposes, a lien, a claim. A mortgage is also a hypothèque in French, hypothecation, remember. Predatory suits, while not then entertained by the English Admiralty Court, are recognized in the United States as indubitable and convenient modes of exercising the maritime jurisdiction. To give you just one example of how this special maritime and territorial jurisdiction of the United States is applied, we can go back to 1998 in the United States District Court for the District of Colorado. Wait a minute, I thought Colorado was a state. No, Colorado is a United States district. You see, this is what we need to learn. We need to learn our place. We need to learn that we've been conquered. A woman was charged with three counts of misdemeanor violations, including violations of Title 16 of U.S. Code, Section 551, Title 43 U.S. Code 1761, and related regulations. These violations were for using Forest Service, i.e. United States Forest Service, roads without a special use authorization and for not obtaining a required permit. Okay, the information clearly states that the offenses occurred within the special maritime and territorial jurisdiction of the United States. So, where was she tried? Well, she thought she was in a state. Of course, none of us know what's going on. So she was, of course, tried in a maritime court, found guilty and sentenced to jail and to pay a fine. Her defense was obviously unsuccessful. Had she challenged the subject matter jurisdiction of the court and shifted the burden of proof to the U.S. attorney to prove the jurisdiction, her case might have been dismissed. Had she known what has just been revealed, she might have asked questions such as, is it presumed that her body is a vessel under 18 U.S. Code 7.1, Section 1? Is it presumed that the car she was driving is a vessel under subsection 2? Is it presumed that the United States acquired the land where the United States is exercising its special maritime and territorial jurisdiction? Was conveyed to the United States by the legislature of Colorado? And if so, where is the enactment by the Colorado legislature that conveyed the land as mandated by Article 4, Section 3 of that Constitution? Is it presumed that Colorado did not enter the union of the several states on equal footing with all the others according to the equal footing doctrine, and is not a state but remains a territory of the United States, that is? Is it presumed that Colorado is located on the moon? Is it a presumption that the Social Security insurance contract has bound the defendant into a special maritime jurisdiction? Is it presumed that the defendant or the defendant's car was engaged in interstate commerce? Had she challenged these subject matter presumptions, shifted the burden of proof, she might have actually, been set free and realized there was no crime. She didn't need permission. However, we're ignorant. We don't know these things. There's no reason we would. We're not taught this in school. We're public-minded creatures, animals, soulless beasts who are not self-governing. So, how could we possibly know to ask such questions? But let's talk about these questions a little bit. I started making a documentary a couple years ago. I don't remember when exactly. It was maybe 3 or 4 years ago. And it was called Citizen Enslavement. Yes, that's right. Citizen enslavement. That's my new word. It's one word. Citizen enslavement. See, enslavement is in there. Cities, enslavement. Citizen enslavement, you see. And the reason, of course, I say that is because, again, we're citizens. Wow. I want you to imagine for a moment this word citizen, which we'll probably end up covering either this show or next show. But I want you to consider what a citizen is. Do you think a citizen implies freedom? Well, in a way it does. You're given, we've talked about this before, you're given a franchise to act within the jurisdiction, which we call freedom. That's legal freedom. That's not true freedom. You're in a vessel, so you can't have real freedom. You're not a vessel of God. You're not acting as an act of God or nature, so you don't have freedom in nature. You're under a strict law of the vessel. You don't get to walk on water like Jesus did because you're not following the law that Jesus gave you, the example. You need a vessel. and therefore you're under the law of the vessel, floating on the sea, never touching the land. You starting to get how the Great Flood works? So Citizen Enslavement was a documentary that I was making about federal lands, about the Bundy Ranch incident, and how much bullshit went on there. Did the Bundys have any kind of right to do what they thought they were doing? And the answer is no, absolutely not in any way if you're just considering the law. If you're considering the moral concept, well, then absolutely. But we're not talking about that. We're talking about the law. Did they have a lawful right to do anything that they did? Did they have a lawful right to go up against the United States on its own land? No, of course not. And to be even more clear, were the Bundys operating as private citizens or as citizens of the United States, and was their land incorporated under the United States or not? And the answer is they're citizens of the United States, on public land, with a corporation that they called their quote-unquote ranch. I can't remember the name of the corporation at the moment, but you can look it up. So, big whammies here, right? Once you incorporate land, I experienced this on my own, where I watched this farmer, after he incorporated his land, suddenly they started picking it apart because now it's, in the United States jurisdiction. And so all of a sudden the eminent domain laws came into effect and he was screwed. He screwed himself out of his own land. But he wanted the security and the peace of mind that comes with incorporation. You fools. That's like saying, I want the peace of mind and comfort and ease and, air conditioning that comes with signing the frickin' contract with the devil. No, it's going to be heat. It's going to be fire, not air conditioning. It's not going to be comfort. It's not going to... No, you're looking for pain. And it's your right as a United States citizen to be put in pain, remember? Title 42, Section 1981. Okay, so let's not get sidetracked. Let's go right into this. So I've been working on just editing because I've been sick. I'm like, what can I do to not have to talk so much? And so I went ahead and I edited a lot of the stuff that I already recorded. Unfortunately, I don't have the paper, the actual things popping up on the screen like I do in my documentaries. But this will give you an accurate history, according to government research papers, etc. Nothing of my opinion, or anybody else that you know. This is purely the government research centers that it'll give you an idea of how federal lands work. It'll start to make you understand that, hey, the people of each state, especially after the Civil War, which is something we'll cover next week as far as the Civil War, and that it never ended, by the way, never really truly ended. This is why the federal United States is so prevalent everywhere, why the states have no power against it, why states cannot secede according to their own constitutions. We'll talk about that probably next week, unless we can get to it today. So what this is going to be is a lesson on federal lands. What are your rights on federal lands? How much land is federal, especially in the West? And how it is that this happened, which of course, before the states could become states, they had to obey what were called the Enabling Acts before the president would sign off and Congress would allow states to be formed from federal territories. Then, of course, all of these Enabling Acts had to be met, all these requirements. One of those, of course, was what you're going to be hearing a lot of right now, which is that the people of the state forever disclaim right to public ownership, public title of public lands. In other words, all the lands, like I said, 83% of Nevada is in federal ownership. Yes, you see the entirety of Nevada marked out as a quote-unquote state, but that is the United States. Most of that land is United States. So I'm going to play this. It's going to take up most of the show, if not all, and we'll continue this next week as well. I'll come back to say goodbye. Again, I apologize for my toad-like voice today. I have been sick. Here we go. Recent events at the Bundy Ranch in the state of Nevada have sparked many controversial debates regarding the state of the Union. Some considered this event an historical victory for the people. A much smaller minority have considered it an organized false flag event, meant to place a false sense of security into the hearts and minds of the citizenry, promoting the illusionary rights of the people and of the state itself. And yet others demonize the situation and use it as a platform for stricter gun control. In truth, the general population of those who claim citizenship of and within the United States government have been conned into a culture of romanticism and delusional belief as to the true nature of just what the United States is. In this film, we will uncover the reality of our collective disposition in this military-occupied nation, to discover a population that desperately clings to a fallacious, nationalist sense of being a free people, while simultaneously obediently submitting to a tyrannical and violent government. We will uncover the true history of the United States, beginning with the so-called Civil War, examining just how and why the American dream is purely a fictional tale. With the use of the 50 individual state and U.S. constitutions, legal code, and many other official government and primary sources, the true story of America's past and present will become painfully clear. Perhaps we should begin our journey with an examination of the Bundy Ranch incident itself. The statement was made that the federal militarized police were treading upon Nevada state land in their mission to steal openly the Bundy's cattle. But is this indeed a true statement, or just one of many patriotic myths that needs to be dispelled? Does the so-called public land managed by the Bureau of Land Management, or BLM, actually belong to the state of Nevada? The answer will certainly surprise you. In order to answer this question without any doubt, we must first understand the history and constitution of just how the state of Nevada was formed within the already existing territory of the United States. Before any of the post-Civil War states could be admitted into the United States, which were in reality merely corporate borders formed within the already existing claim of United States territorial ownership and trust, by and under military conquest and rule of the United States, the eligible to vote United States citizens that occupied that United States territory were required to petition the central government and its Congress for permission to form a new state. In fact, the creation of each state was done so through a United States Congressional Act, which are also referred to as the Enabling Acts. Then and only then was a state constituted by presidential declaration. Each state of the Union was required to agree to these enabling acts, a strict set of requirements by the U.S. Congress, before they could incorporate as a state. There was literally no choice. The state of Nevada, for instance, was created by the Act of Congress of 1864, enabling the people of Nevada to form a constitution and state government. In other words, the state of Nevada was created as a subcorporation of the United States, through articles of incorporation that are called a Congressional Act, which had to meet certain requirements before it was enabled by the United States to become a corporate state. Just as Microsoft Corporation has many independent companies or subcorporations within its mother corporation and holding company, so too does the United States. Likewise, Microsoft owns those subcorporations and has similar enabling acts and requirements. In other words, Microsoft Corporation is the central government of all of its subcorporations. Like any franchise of any other conglomerate corporation, each state is also given the privilege of limited self-governance. This is to say that the citizens inhabiting that particular area of the already claimed territory of the United States are allowed the benefit of suffrage, meaning to vote for what they deem to be the representatives of the state. These, however, should not be confused as being representatives of the people any more than a middle manager at a private company should be considered a representative of that corporation's employees. A manager manages people while doing the bidding of its president and board of directors. Representatives are indeed more like a board of directors of the state corporation, and have the state's best interest in mind as a franchise of the United States, wherein they are assigned to control the people like Mr. Bundy controls his cattle, as profit-driven commodities. The state government is merely a political body or sub-corporation of the United States, which is indeed fully under the control and law of the United States. Like any corporate chain of restaurants or department stores, each sub-corporate state is allowed to politically self-govern itself in matters that do not necessarily affect or oppose the mother corporation's rules and laws. In this case, the United States Federal Code and what is referred to as the law of the land. Your elected state officials are titled as members of Congress. In other words, they work as employees of the United States, not the state, and hold their official titles and offices in Washington, D.C. They operate the state as a franchise of the United States, in the capacity of an officer of the United States, similar to a district manager. And, of course, each state and zip code are all considered to be within federal districts. So what does it mean to be a member of the United States Congress? From Bouvier's Law Dictionary of 1856, also known as and commissioned by Congress as the official Dictionary Act of Congress, we read that the word member is defined as an individual who belongs to a firm, partnership, company, or corporation, and one who belongs to a legislative body or other branch of the government, as a member of the House of Representatives, a member of the court. Member of Congress is also defined here as a member of the Senate or House of Representatives of the United States. To be clear, Black's Law Dictionary, first edition, defines the word belong in statutes referring to inhabitancy, the poor, etc., designates the place of a person's legal settlement, not merely his place of residence. We must remember that in law, words like him and his does not generally refer to sex, and that a person is in fact a corporation of some sort, specifically referring to artificial legal things. So let's pose the question. Can an act of Congress be anything but a corporate construct and possession of the United States? In fact, no. A thing created belongs to its creator. Thus, each state, as a creation of congressional action, belongs to the United States. States that already existed before the Civil War were readmitted and reconstituted, being required and militarily forced to agree and consent to the newly enforced Reconstruction Amendments within revised state constitutions. In Section 1 of the Nevada State Enabling Act, we see that Congress gave its authorization to form the state of Nevada to the people, only after the people asked permission. And so you must ask yourself, would a free people really need anyone's permission to do anything if they were truly free? Here we also read that the newly formed state is by law admitted to the Union. So what does that mean? Again, from Bouvier's Dictionary Act of 1856, we read, admission in corporations or companies, the act of the corporation by which an individual acquires the rights of a member of such corporation or company. Now again, the word individual still refers to a person or corporation. Admittance. In English law, the act of giving possession of a copyhold estate upon the surrender by the former tenant and upon descent. Nevada, its people being the individual as a collective body politic, became a member of the Union, whereby certain rights were given over to that state as revocable privileges. The state subcorporation now holds possession of the estate of the United States.
which is the territory with a corporation body politic upon it called a state. In reality, to be admitted to the Union was a consequence of military action under Civil War, requiring the surrender of all possessions to the United States. In other words, this was an act of war against the people of each state, forcing each state to accept the 13th and 14th Amendments, which made all individual persons into federal United States citizens. Here we also read that the word surrender refers to estates and the conveyancing of property. It is defined as a yielding up of an estate for life or years to him who has an immediate estate in reversion or remainder, by which the lesser estate is merged in the greater by mutual agreement. A surrender immediately divests the estate of the surrenderer and vests it in the surrenderee, even without the assent of the latter. The technical and proper words of this conveyance are surrender and yield up, but any form of words by which the intention of the parties is sufficiently manifested will operate as a surrender. The deed or instrument by which a surrender is made is also called a surrender. The United States, in this case, is the surrenderee, the corporation or one to whom a surrender has been made. The people, as a collective body politic, e pluribus unum, or one voice, is the one who makes a surrender, as when the tenant gives up the estate and cancels his lease before the expiration of the term, one who yields up a freehold estate for the purpose of conveying it. The 1889 Dictionary of Law by William C. Anderson also defines surrender as to give up, make over, deliver, also such act itself. Also from Bouvier's 1856 we read that possessions under international law is a country which is held by no other title than mere conquest. Note that the end of the Civil War was indeed the conquest of all states, both the consenting North and the belligerent South. Possession is also defined as property, the detention or enjoyment of a thing which a man holds or exercises by himself or by another, who keeps or exercises it in his name. Possession is natural or civil. Possession is civil when a person or corporation ceases to reside in the house or on the land which he occupied, or to detain the movable he possessed, but without intending to abandon the possession. The state of Nevada is a country, an incorporated body politic that is held in military conquest by the United States as a territorial possession. The people, or citizens of the United States within that fictional border called State of Nevada, are allowed to enjoy the use of that corporation, or state, of, meaning belonging to, the United States. Nevada, as all states, is a United States civil possession of property through surrender of war. And as we will come to realize, the United States has no intention of ever relinquishing its title over its military conquest called America and its 50 states. Even the Dictionary Act commissioned by Congress itself, Bouvier's Law Dictionary of 1856, admits of the corporate nature of the United States government. The United States of America is defined as a corporation endowed with the capacity to sue and be sued, to convey and receive property. But it is proper to observe that no suit can be brought against the United States without its authority of law. It goes on to say that the states, individually, retain all the powers which they possessed at the formation of the Constitution, and which have not been given to Congress. Besides the states which are above enumerated, there are various territories, which are species of dependencies of the United States. New states may be admitted by Congress into this union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of two or more states, or parts of states, without the consent of the legislatures of the states concerned, as well as Congress. In other words, states do not have the power or authority, as believed, to secede from the Union. This fact will become ever more clear as we proceed. Under the Dictionary Act definition of corporation, we read, corporations are divided into public and private. Public corporations, which are also called political, and sometimes municipal corporations, such as counties and cities, are those which have for their object the government of a portion of the state. Another class of public corporations are those which are founded for public, though not for political or municipal purposes, and the whole interest in which belongs to the government. Nations or states are denominated by publicists, bodies politic, and are said to have their affairs and interests, and are deliberate and resolve in common. They thus become as moral persons, having an understanding and will particular to themselves, and are susceptible of obligations and laws. In this extensive sense, the United States may be termed a corporation, and so may each state singly. In the case of Dartmouth College against Woodward, Chief Justice Marshall describes the corporation to be, quote, an artificial being, invisible, intangible, and existing only in contemplation of law. Being the mere creature of law, continues the judge, quote, it possesses only those properties which the charter of its creation confers upon it, either expressly or as incidental to its very existence. These are such as are supposed best calculated to effect the object for which it was created. Among the most important characteristics are immortality, and, if the expression may be allowed, individual properties by which a perpetual succession of many persons are considered as the same, and may act as the single individual. They enable a corporation to manage its own affairs, and to hold property without the perplexing intricacies, the hazardous and endless necessity of perpetual conveyance for the purpose of transmitting it from hand to hand. It is chiefly for the purpose of clothing bodies of men in succession with these qualities and capacities that corporations were invented and are in use. It is essential to understand the hierarchy of creation here, for the individual states would not exist without the corporation of the United States that created them. The word person is applied to men, women, and children who are called natural persons. In law, though, man and person are not exactly synonymous terms. Any human being is a man, whether he be a member of society or not, whatever may be the rank he holds, or whatever may be his age, sex, etc. A person is a man considered according to the rank he holds in society, with all the rights to which the place he holds entitles him, and the duties which it imposes. It is also used to denote a corporation, which is an artificial person. But when the word persons is spoken of in legislative acts, natural persons will be intended, unless something appear in the context to show that it applies to artificial persons. Persons are divided into citizens and aliens when viewed with regard to their political rights. When they are considered in relation to their civil rights, they are living or civilly dead, sometimes called civil death, outlaws, and infamous persons. The word personality is defined as an abstract of personal, as the action is in the personality. That is, it is brought against a person for a personal duty which he owes. It also signifies what belongs to the person, as personal property. When referring to personal property, the word personal means belonging to the person, not the man. This adjective is frequently employed in connection with substantives. Things, goods, chattels, actions, rights, duties, and the like as personal estate, but in opposition to real estate, personal actions, in contradistinction to real actions, personal rights, and those which belong to the person, not the man. Personal duties are those which are to be performed in person, referring to the man acting in the capacity of an artificial person. Personable means having the capacities of a person, not a man. For example, the defendant was judged personable to maintain this action. On December 3, 2007, the Congressional Research Service made its report for Congress entitled Federal Land Ownership, Constitutional Authority, and the History of Acquisition, Disposal, and Retention. This report was prepared for members and committees of Congress. In the summary, it states, federal land ownership began when the original 13 states ceded their western lands between the Appalachian Mountains and the Mississippi River to the central government between 1781 and 1802. Substantial land acquisition in North America via treaties and purchases began with the Louisiana Purchase in 1803 and culminated with the purchase of Alaska in 1867. In total, the federal government acquired 1.8 billion acres in North America. The U.S. Constitution addresses the relationship of the federal government to those lands. Article 4, subsection 3, Clause 2, the Property Clause, gives Congress authority over federal property generally, and the Supreme Court has described Congress's power to legislate under the clause as without limitation. The equal footing doctrine, based on language within Article 4, subsection 3, Clause 1, and found in state enabling acts, provides new states with equality to the original states in terms of constitutional rights, but has not been used successfully to force the divestment of federal lands. The policy question of whether to acquire more or to dispose of any or all federal lands is left to Congress to decide. The initial federal policy generally was to transfer ownership of many federal lands to private and state ownership. Congress enacted many laws granting lands and authorizing or directing sales or transfers, ultimately disposing of 1.275 billion acres. However, from the earliest times, Congress also provided for reserving lands for federal purposes, and over time has reserved or withdrawn areas for such entities as national parks, national forests, and wildlife refuges. The Taylor Grazing Act of 1934 was enacted to remedy the deterioration of the range on the remaining public lands. This was the first direct authority for federal management of these lands, and implicitly began the shift towards ending disposals and retaining lands in federal ownership. In 1976, Congress formally declared that national policy was generally to retain the remaining lands in federal ownership in the Federal Land Policy and Management Act. The Sagebrush Rebellion was a collection of unsuccessful state and local efforts, beginning in 1978, to assert title to federal lands or force their divestiture. It also included efforts by the Reagan administration and in Congress to divest of many federal lands, which also proved unsuccessful. Legislation on federal land disposal continues to be considered. Bills for the wholesale disposal have not been introduced in more than a decade, but legislation has been introduced to limit federal land ownership or acquisition, to expand disposal authorities, at least in some areas, to sell lands to pay for other activities, and to accelerate currently authorized land sales. Because the extent of federal lands and the authority to acquire and dispose of federal lands are an enduring policy question, Congress faces continued consideration of federal lands legislation. Federal land ownership. The federal government has retained about a third of the 1.8 billion acres it acquired in North America. These lands are heavily concentrated in 12 western states, including Alaska but not Hawaii, where in total the federal government owns more than half of the land, ranging from 30% in Montana to 84% in Nevada. Many Western citizens and members of Congress continue to express concerns about what they feel is excessive federal influence over their lives and economies, and assert that the federal government should divest itself of many of these lands. Others support the policy of retaining these lands in federal ownership. This report describes practices and authority for federal land ownership and retention. It presents background on disposal, withdrawal, and retention policies. The report concludes with a summary of the Sagebrush Rebellion, efforts to force divestiture of federal lands, and issues for Congress on disposing or retaining federal lands. Federal land acquisition. Federal land ownership began when the original 13 states ceded title to more than 40% of their western lands, 237 million acres between the Appalachian Mountains and the Mississippi River, to the central government between 1781 and 1802. Federal land acquisition from foreign countries began with the Louisiana Purchase, 530 million acres in 1803, and continued via treaties with Great Britain and Spain, 76 million acres, in 1817 and 1819, respectively. Other substantial acquisitions, 620 million acres, via purchases and treaties, occurred between 1846 and 1853. The last major North American land acquisition by the U.S. federal government was the purchase of Alaska, 378 million acres, in 1867. At its inception, the federal government did not own land in the original states of the Union. Rather, ownership of lands between the Appalachian Mountains and the Mississippi River was ceded by the original states, and additional states were formed from those lands. Lands were primarily acquired by the U.S. federal government from foreign governments, as was Florida, which was acquired from Spain. The means by which the federal government came to own its lands can affect which laws govern the land's management. The public domain lands, primarily those obtained from a foreign sovereign, typically are governed by different laws than are lands acquired from states or individuals. The constitutional basis for federal land ownership, the Property Clause. The U.S. Constitution addresses the relationship of the federal government to lands. The Property Clause, Article 4, subsection 3, Clause 2, gives Congress authority over the lands, territories, or other property of the United States. It reads, "The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States." This provision provides broad authority for Congress to govern the lands acquired by the federal government as it sees fit, and to exercise exclusive authority to decide on whether or not to dispose of those lands. The U.S. Supreme Court has described this power as without limitation, stating that, while Congress can acquire exclusive or partial jurisdiction over lands within a state by the state's consent or cession, the presence or absence of such jurisdiction has nothing to do with Congress's power under the Property Clause. Absent consent or cession, a state undoubtedly retains the jurisdiction over federal lands within its territory, but Congress equally surely retains the power to enact legislation respecting those lands pursuant to the Property Clause. And when Congress so acts, the federal legislation necessarily overrides conflicting state laws under the Supremacy Clause. One authoritative commentary noted that no appropriation of public lands may be made for any purpose except by authority of Congress. Congress may limit the disposition of the public domain to a manner consistent with its views of public policy. It, the Property Clause, empowers Congress to act as both proprietor and legislature over the public domain. Congress has complete power to make those needful rules, which in its discretion it determines are necessary. When Congress acts with respect to those lands covered by the Property Clause, its legislation overrides conflicting state laws. Absent action by Congress, however, states may in some instances exercise some jurisdiction over activities on federal lands. Thus, it is accepted law that the federal government may own and hold property as Congress directs. Issues such as whether some or all of the remaining federal lands should be retained or divested, how to dispose of lands, or whether to acquire additional federal lands appear to be policy questions for Congress. The Equal Footing Doctrine. The Equal Footing Doctrine is based on Article 4, subsection 3, Clause 1 of the Constitution. That clause addresses how new states will be admitted. The doctrine means that equality of constitutional right and power is the condition of all states of the Union, old and new. It does not, however, mean that physical or economic situations among states must be the same. The term comes from the State Enabling Acts that included the phrase that the state was admitted into the Union on equal footing with the original states. The U.S. Supreme Court has clarified what those rights are. In the context of land, the equal footing doctrine has been held to mean that states have the authority over the beds of navigable waterways. Some have argued that the equal footing doctrine prohibits permanent federal land ownership. This is contrary to the plain wording of the Constitution. The doctrine and some language within the U.S. Supreme Court case of Pollard's Lisi v. Hagan have been combined to provide an argument that the federal government held the lands ceded by the original states only temporarily pending their disposal. However, this theory has been rejected by other Supreme Court cases. Furthermore, in that case, the Supreme Court ruled on the narrow issue of federal land ownership of submerged lands between the navigable waters, finding those lands belonged to the state under the equal footing doctrine because the original states had kept ownership of the shores of navigable waters and the soils under them. Federal land disposal. The initial policy of the federal government generally was to transfer ownership of many of the federal lands to private and state hands, to pay Revolutionary War soldiers, to finance the new government, and later to encourage the development of infrastructure and the settlement of the territories. In October 1780, even before the Articles of Confederation were ratified, the Continental Congress adopted a general policy for administering any lands transferred to the federal government. The lands were to be disposed of for the common benefit of the United States, were to be settled and formed into distinct republican states, which shall become members of the federal union, and shall have the same rights of sovereignty, freedom, and independence as other states. The lands were to be granted and settled at such times and under such regulations as shall hereafter be agreed on by the United States in Congress assembled. The need for revenues to pay off the national debt was a driving force in the debate over land disposal systems. The Continental Congress balanced the need for revenue with other needs, such as compensating veterans and providing for public schools in enacting the Land Ordinance of May 20, 1785, to address the lands in the Ohio Territory, north of the Ohio River and west of Pennsylvania. After extensive debates, the Continental Congress essentially followed an approach for land disposal that included several provisions that were used in most federal land disposal legislation over the next 50 years, including prior rectangular survey before disposal, public auction of the surveyed lands, a minimum price, and at least one section, 1/36th, of every 6-mile square township, for the maintenance of public schools within the said township. Questions about the governance of these lands, including potential statehood, were resolved by the Continental Congress in the Northwest Ordinance of 1787, and at nearly the same time and in nearly the same manner by the Constitutional Convention drafting the new U.S. Constitution. The decision was to have initial administration by a federally appointed governor, followed by shared authority between an appointed governor and a representative assembly, culminating in statehood on an equal footing with the original states. The Constitutional Convention also addressed concerns about statehood for the western lands. Robert Morris from Pennsylvania expressed apprehensions about the impact on the developed East by Western congressional representation by unschooled frontiersmen. This concern was addressed in Article 4, subsection 3, Clause 1, which requires the consent of both Congress and the legislatures of the existing states from which the new state is created. Charles Carroll from Maryland noted the concern of small states that the consent provision, together with the existing state claims to the western lands, such as the Ohio Territory, could prevent eventual statehood for those lands, because the state claiming the land could deny its consent. This was then addressed by requiring the original states to cede title to those western lands to the central government. The new federal government took various actions regarding lands, including settling conflicting claims, granting lands to veterans for military service and other purposes, and selling the remaining lands under various programs. The first land offices to resolve land claims and sales were established by Congress in Ohio in 1800, and the General Land Office was established in 1812 to administer the disposal of federal lands. Congress enacted numerous laws to grant, sell, or otherwise transfer federal lands into private ownership, including the Homestead Act of 1862 and the General Mining Law of 1872. Grants to railroads in the 1870s gave them incentives to create much of the nation's transportation system. Nearly 816 million acres of the public domain lands were transferred to private ownership between 1781 and 2006. Most, 97%, occurred before 1940. Homestead entries, for example, peaked in 1910 at 18.3 million acres, but dropped below 200,000 acres annually after 1935, because the best agricultural lands were already taken. The federal government also granted 328 million acres to the states. The single largest state grant was in 1958. Under the Alaska Statehood Act, the state of Alaska could select up to 103.35 million acres, under certain constraints. Also, the Alaska Native Claims Settlement Act authorized various regional and village native corporations to select 40 million acres of federal land within the constraints identified in the Act. Through 2006, 93.1 million acres have been transferred to the state of Alaska, while 37.7 million acres have been transferred to native corporations. In total, the federal government has disposed of 1.275 billion acres of the 1.841 billion acres it acquired from state cessions, foreign treaties, and land purchases. Federal land withdrawals. Although early federal policy generally was to dispose of many of the lands it had acquired, increasingly over time, Congress withdrew lands, removed them from disposal under some or all of the disposal laws, or reserved lands, withdrew them for a particular national purpose. For example, the Land Ordinance of 1785 reserved Section 16 of every township to maintain public schools. The Act of 1796 made permanent many of the provisions of the Land Ordinance of 1785, and provided that, instead of reserving scattered sections for future disposal by Congress, the 4 central sections of each township were to be retained. In 1798, Congress authorized and funded military reservations for building fortifications at the discretion of the President. Early withdrawals were primarily to retain lands for future disposals or for Indian trading posts, for military and mineral reservations, or for other public purposes. The establishment of Yellowstone National Park in 1872 led the way to preserving certain lands for recreation and for the future, with other national parks designated later. This eventually led to the National Park Organic Act and to the National Park System. In 1891, the President was authorized to protect other federal lands by proclaiming forest reserves. This eventually led to the creation of the National Forest System. In 1903, President Theodore Roosevelt began the practice of withdrawing federal lands to protect wildlife habitats, which led to the National Wildlife Refuge System. Today, the National Park Service, the U.S. Forest Service, and the U.S. Fish and Wildlife Service manage the lands to preserve parks, conserve forests, and protect wildlife and wildlife habitat, respectively. These three agencies managed 360 million acres, about 55% of all federal lands. Additional, though more modest, withdrawals have been made from military reservations and for federal purposes. Federal land retention. As noted earlier, the General Land Office was established as part of the Treasury Department in 1812 to oversee the disposal of public lands through land sales, homesteading, grants to railroads and to states, and other means. The office's Division of Forestry was responsible for the forest reserves beginning with their establishment in 1891, but in 1905 this division was transferred and merged into the Department of Agriculture's Bureau of Forestry to form the new U.S. Forest Service. The General Land Office remained in the business of principally overseeing the disposal of many of the remaining federal lands and maintaining federal title records and documents. The U.S. Grazing Service was created in 1934 to administer many of the public lands for livestock grazing under the authority of the Taylor Grazing Act of 1934. Although the act referred to managing those lands, quote, pending their disposal, unquote, the act implicitly began the shift in federal law towards ending disposals and retaining lands in federal ownership. This act was intended to remedy the deterioration of remaining public lands, apparently due to overgrazing and the drought and depression of the 1920s and 1930s. It was the first direct authority for federal management of lands which previously were freely available for transient grazing, and reflected the significant decline in homestead entries. In part because of controversies over its management efforts, the Grazing Service was terminated in 1946 by merging it with the General Land Office to form the Bureau of Land Management, or BLM. The debate over federal retention of the remaining public lands endured for decades. The shift towards explicit federal policy to retain these lands continued with two laws enacted in 1964. One created the Public Land Law Review Commission, PLLRC, to review existing public land laws and regulations, and to examine the policies and practices of the federal agencies which administered the federal lands. The 1970 PLLRC report contained 137 specific legal and policy recommendations for improving federal land management. The first recommendation was that the existing federal lands should generally be retained in federal ownership, where it stated, "We, therefore, recommend that the policy of large-scale disposal of public lands reflected by the majority of statutes in force today be revised, and that future disposal should be only those lands that will achieve maximum benefit for the general public in non-federal ownership, while retaining in federal ownership those whose values must be preserved so that they may be used and enjoyed by all Americans." The other 1964 law, the Classification and Multiple Use Act, directed the Bureau of Land Management to classify lands for retention or for disposal and to manage the lands for multiple purposes, pending the PLLRC recommendations. By 1970, when that report was released, BLM had classified more than 90% of the remaining unreserved public domain lands for retention. This reflected the decline in federal land disposal to nearly zero in the 1960s. The future of public lands, including the issue of retention or disposal, was debated in 3 Congresses following the release of the PLLRC report. Finally, enactment of the Federal Land Policy and Management Act of 1976 formally ended the previous disposal policy, expressly declaring that the national policy generally was to retain the remaining lands in federal ownership. Section 102A of the FLPMA states, "The Congress declares that it is the policy of the United States that 1. The public lands be retained in federal ownership unless as a result of the land use planning procedure provided for in this act, it is determined that this particular parcel will serve the national interest." FLPMA also amended many previous management authorities and public land and resource laws, and repealed most land disposal laws. Section 702 repealed the many statutes and sections authorizing homesteading, although the effective date of the repeal was delayed for 10 years in Alaska. Section 703 similarly repealed and delayed the effective date in Alaska most other statutes authorizing land sales or transfers. FLPMA did authorize the sale of some specific tracts of public lands, quote, at a price not less than their fair market value, unquote, under conditions specified in the Act. BLM currently manages 258 million acres of land, 39.5% of all federal land and 11.4% of all land in the United States. A third of BLM lands, 83.5 million acres, are in Alaska. The remainder is substantially concentrated in 11 western states and accounts for significant amounts of land in most of those states. BLM also manages 387,721 acres in states east of the Rocky Mountains, with 70% of those lands in South Dakota. BLM lands are administered for the sustained yield of multiple uses, including recreation, livestock grazing, timber harvesting, watershed protection, and wildlife and fish habitat management, although users typically want higher outputs than BLM provides, while environmental groups typically want more protection and lower outputs. This table summarizes the current federal lands reserved for or otherwise retained or acquired by the four major federal management agencies. Here we see federal lands by state or region and by agency. Listed in the millions of acres, we see that of the total lands in the United States, within each state individually, a total of 28.8% of that land on the surface area of the United States is indeed federally owned. In the 11 western states, including Nevada, 46.9, or almost half of the acreage, is owned by the federal government. And almost 70% of the total surface area of Alaska is also owned by the federal government. The 11 western states include Arizona, California, Colorado, Idaho, Montana, Nevada, New Mexico, Oregon, Utah, Washington, and Wyoming. The other category includes the other 38 states, the District of Columbia, Puerto Rico, Virgin Islands, Guam, and other insular lands or possessions. The Sagebrush Rebellion. At various times, efforts have been made to turn over remaining unreserved public domain lands to the states. Until 1976, many Westerners retained the hope that the substantial federal presence might be reduced through additional federal land transfers to private or state ownership. However, FLPMA repealed most of the authorities for such ownership transfers and established an official policy of retaining the remaining lands. Thus, these Western interests faced a future with a substantial and permanent federal presence. As much as 84% of the land in Nevada, 69% in Alaska, 57% in Utah, 53% in Oregon, and 50% in Idaho. The Sagebrush Rebellion was largely a reaction to these facts. The Sagebrush Rebellion was a collection of efforts to force the federal government to divest itself of federal lands. These efforts took the form of state and local legislation, court challenges, federal administrative changes, and efforts to federal legislations. The target was usually BLM lands, but sometimes included national forests. These efforts failed for a number of reasons. A fundamental obstacle was that Nevada and other states agreed as a condition of statehood to disclaim forever all right and title to the unappropriated public lands lying within said territory, and that the same shall be and remain at the sole and entire disposition of the United States. This language was part of the Enabling Act creating the states, and was incorporated into their constitutions. Therefore, the state laws asserting title to those federal lands appeared to contravene their own constitutions. At any rate, the state laws were not enforced. The rebellion was more effective as a political movement than a legislative one. And in this author's opinion, it created many fallacies about state ownership of federal lands. State and local efforts. In 1979, Nevada enacted a state law asserting state title and management and disposal authority over public BLM lands within Nevada's boundaries. Similar state laws asserting state authority over public lands were passed in Arizona, Hawaii, Idaho, New Mexico, North Dakota, Utah, and Wyoming. Other attempts to enact similar state laws were less successful. Legislation in California, Colorado, and South Dakota was vetoed, although a weaker version of the California bill was passed that did not require the governor's signature. A Washington state measure contingent on an amendment to the state's constitution also failed. In 1978, the state of Nevada began its court challenge of the constitutionality of the federal land retention policy in subsection 102A of the FLPMA. Nevada argued that the federal government could only lawfully hold public lands in a temporary trust pending eventual disposal, and that retention of the lands violated the equal footing doctrine. The Federal District Court of the District of Nevada dismissed the case for failure to identify a claim upon which relief could be granted. The court found that any limitations on holding lands ceded by the original states did not apply to Western lands acquired after the Constitution went into effect, and that the equal footing doctrine did not mean that the newer Western states were entitled to the public lands. The court noted that the equal footing doctrine applied only to political and sovereignty rights and not to economic or geographic equality, and that the Constitution reserved to Congress the authority to decide which federal lands to sell or to keep. On the symbolic date of July 4th, 1993, Nye County in Nevada took action on federal lands, using a bulldozer to open closed roads, based on the assertion that Nevada held title to the lands. The United States filed suit, seeking a declaratory judgment that it owned and had authority to manage the disputed lands within Nye County, and that the county resolution regarding roads and right-of-way was invalid. The United States, of course, prevailed in its own federal court. County governments in several states also have asserted local authority over federal lands and attempted to specify management of those lands. Catron County, New Mexico, has a vanguard in asserting local control over federal property. Its ordinance was repealed a year later, however. Local laws that impose direct management requirements on the lands or require local approvals for land use changes almost certainly are preempted under the Supremacy Clause, Article 6, Clause 2 of the U.S. Constitution if they conflict with federal laws, regulations, or purposes. Private entities have also challenged federal land ownership. In one case, the plaintiffs asserted that they did not need a permit to graze livestock in a national forest because the state of Nevada owned the lands. Both the lower and appellate courts again rejected the arguments that Nevada was entitled to the lands under the equal footing doctrine, or that the federal government had any obligation whatsoever to turn lands over to states. Administrative efforts. President Reagan attempted to address the issue administratively in the early 1980s. That administration's concept of reducing federal influence in the West slowly changed from transferring the lands free of charge to selling the lands at fair market value. Several factors stimulated this shift, including pressure from Congress and the rising federal deficit. Eventually, President Reagan issued an executive order establishing the Property Review Board to review federal real property for potential disposal. It was not clear how this initiative related to the existing laws such as FLPMA that provide statutory criteria for reviewing lands for disposal and contain an express policy of retention. The asset management program eventually stalled, however, because the administration sought clear congressional authorization for land disposal before it would identify which lands might be disposed of, and Congress refused to consider legislation to authorize such disposal until the administration had identified which lands might be disposed of. Congressional efforts. The history of the foregoing state, local, and administrative efforts made it clear that reducing federal land ownership would require an act of Congress. Bills were introduced in the 95th, 96th, and 97th Congresses from 1977 to 1982 to change the retention policy in FLPMA. In general, these bills would have authorized transferring the unreserved lands to the states upon application if the state had a land management agency with a multiple-use mandate. However, none of these bills was reported by a committee or considered on the congressional floor. Efforts to legislate a reduction in federal land ownership were revived in 1994 with the election of Republican majorities in the House and the Senate, and the vision of shifting federal control towards the states was embodied in the House Republican Contract with America. Organizations supporting this vision, such as the Cato Institute, have advocated extensive disposal of federal lands through privatization and or transfer to state ownership or management. Several bills were circulated or introduced in the 104th Congress for the wholesale transfer of BLM lands or for the transfer of ownership or management of specific federal units, such as specific wildlife refuges or national park system units in one state. Hearings were held on some of the bills, but none was reported by a committee or considered on the congressional floor. General legislation to dispose of federal land saw less congressional attention in the 105th Congress. One bill, Senate Bill 1254, the Federal Lands Management Adjustment Act, would have authorized management of the Forest Service or BLM lands in a state for renewable 10-year terms by the state or a qualified nonprofit organization, but with legislative authorization required for each management transfer. Naturally, Congress held no hearings on the bill. No bills to promote broad divestiture of the federal lands have been introduced since that 105th Congress. Numerous bills have been introduced in most Congresses to transfer individual or groups of parcels, for instance to local governments for public purposes. Several bills and amendments have been offered to prohibit or restrict federal land acquisition in states with 50% or more federal land ownership. The Federal Lands Improvement Act was introduced in the 106th, 107th, and 108th Congresses to accelerate BLM sales of lands identified for disposal under subsection 203 of FLPMA. Again, no congressional hearings were held on this bill. In the 109th Congress, two bills, the Action Plan for Public Lands and Education Act of 2005, would have allowed Western states to select from the unappropriated federal lands, as defined in the bill, up to 5% of the federal land acreage in the state, which could then be leased or sold to generate state funds for education. Again, no congressional hearings were held on these bills. Issues for Congress. Concerns persist among many Western citizens and members of Congress about the extent of federal land holdings and the effect of those lands, and of federal decision-making about the management of those lands on their lives and economies. Legislation addressing the issue continues to be offered, although in recent years the bills have not been for wholesale disposal. Rather, the bills tend to be more limited, capping federal land acquisition or ownership, expanding disposal authorities, typically in limited areas, or otherwise accelerating currently authorized disposals. The agencies have numerous authorities for acquiring and disposing of federal lands. Nonetheless, numerous bills are introduced and considered in each Congress on specific acquisitions, disposals, and exchanges, often because of the limitations in or difficulties with the existing authorities. Other initiatives have been offered to sell federal lands to pay for other programs. The Bush administration has twice proposed land sales to fund a county compensation program. As noted earlier, decisions about the extent of federal land holdings and about acquiring and disposing of federal lands are policy choices for Congress. Such choices are combined with interests in reducing federal presence in the West and with possible sales of federal assets like lands to pay for programs, often including federal land acquisition. Thus, Congress is likely to continue to consider legislation that would alter federal land ownership.
And that, folks, ends the Congressional Research Service report on federal lands. So I'm going to stop there because we're out of time, of course, and thank you for joining us here on Red Pill Sunday School here at UCY.tv. Very much appreciate your listening and your support for the station and myself. I want you to understand that is what you would call the correct, lawful, or legal version. You know, take that as you will. It's not good or not bad. I'm just saying that's how things really are. When we come back next week, we're going to listen to some of the fallacies of some of the journalists and things that have reported on this in various outlets. Compare it to what, of course, you just heard. Obviously, the Bundys had no right to do what they thought they had to do because of the Patriot mythology. That federal lands are, in fact, federal lands and not state lands. And this is something that very much needs to get out there to people so they understand, hey, no, there's no secession. A secession would be a stealing of the federal lands, literally. You cannot California secede. It would be a war, unless Congress actually agrees to it, which would be like taking a big giant shit off into the ocean and closing off that giant blue state, which I'm from, granted. I'm from the northern part, which I have much more forgiveness for. Anyway, that concludes the show. When we come back next week, we will get much more into this and probably take another week just to go over the Civil War and everything. So thanks, guys. Take care. We'll see you next time.